and welcome to Your Special Needs Child is Properly Getting Protected During Your Divorce or Child Support Case. So, recording's live, so here we are, guys. Once again, we're here for ensuring that your special needs child is properly protected during a divorce or a child support case. I'm Carl Ritter with the law firm of Bryan, Fagan, and I'll be doing the presentation today. I work both with the probate and estates and guardianship area within this law firm, and I also work within the divorce areas. I've been practicing for 37 years, been doing this for a good while, so hopefully I can share a lot of insights and practicalities, having just completed one of these cases recently with regards to a special needs child, and I want to go through a little bit of the that experience with you so that you know how to plan to not have the same types of hiccups that my client brought to me, I guess is the best way to put that. So let's get it kicked off this way. According to the Center for Disease and Control, the CDC, also known as the CDC, 1 in 6 children has a developmental disability. Also, the CDC has records to show that 1 in 36 children are diagnosed with autism spectrum disorder, also known as ASD. And so when we're talking about special needs children, there's all kinds of things that get interrelated. Number one, if you're involved in a child support case, you're involved in a divorce case, obviously the first thing we're going to be talking about would be custody issues. And obviously there's the two different the different kinds of custody with regard to a special needs child. There are some issues that go with that. The second issue that we deal with obviously would be the support aspect of it, and keeping in mind that a special needs child, if in fact it qualifies, there is provisions within the family code for a lifetime support order with regard to that child. That's a topic we'll go through in a little bit here, covering that. Thirdly, we'll be dealing with medical care, and that has to do with the fact that most of these children are going to be on Medicaid and or any other number of government programs, and I'm also go through listing out some of those programs a little bit later in this broadcast. Lastly, we'll be looking at what are the public benefits out there, and there are several different government programs out there that are available specifically for a special needs child. The question often gets asked, what's the difference between an ABLE account, that's ABLE account, and that stands for Achieve a Better Life Experience, which is an ABLE account basically is an account that's set up specifically for a disabled child and or adult, and it's specifically designed to assist with their health, independence, and quality of life. Under the IRS code, if you look under the ABLE account areas, you'll notice that almost any and all expenses of a child and or health or benefits, transportation, all kinds of different aspects of that are covered by an ABLE account. And so that's one other account that some people compare to this special needs trust that we're going to be covering today. The other thing I want to comment about special needs trust a little bit outside of this box is that if you do have a special needs child, you really need to be putting a special needs trust in your will. So kind of a bonus tip today, if you have a special needs child, it's very, very important that you go ahead and create for your estate plan that you have a special needs trust designed in there, and you also list who's going to be that person, the trustee for that trust that's making those decisions for your child. And so that's the one section I wanted to talk about. So that's called a testamentary type of scenario where you're putting it in your will. Obviously, that's something I highly recommend all of, especially after you're divorced. You definitely want to make sure that happens because obviously facts have changed. Beneficiaries you probably have listed in your will have changed, so you definitely want to make that change. So let's talk about the special needs trust. Number one, it designs a trust beneficiary that must be diagnosed with a disability or legal requirements. Now, under the Texas Family Code, it sets out what is a disability under Texas Family Code 154.302. So that it lists that a court-ordered support for a disabled child will be required if there's substantial care and personal supervision is required by the child, and the child is not self-supporting or not able to be self-sufficient. Then also under the Family Code, that disability has to have existed prior to the child turning 18 years old. And so when we're talking about divorces or child support cases, we're dealing with a child under the age of 18 normally. And so applying for this lifetime disability, the burden is what I just mentioned. You have to show that this disability existed prior to the 18th birthday. And so many times in divorces that I've handled with this kind of a scenario, I usually would highly recommend getting an IME, which is an independent medical exam that's done with the child through their primary care physician. The reason I mention that is that that's one of the absolute requirements for the guardianships. And so if you're going to have a case involving a special needs child, I always recommend an IME or medical exam, because that gets you over the hump of whether or not, in other words, you've got a medical professional indicating specifically what kind of capabilities the child has. In an IME, the doctor is going to specify what are the limitations of the child physically and or mentally. And the reason that's important is because when you're dealing in guardianships, then you're dealing with either guardianship of the person or you're dealing with guardianship of the estate. In most of my cases, you're specifically going to have the guardianship of the person, because once your child turns 18 as a special needs child, many providers and many other places are going to require you to have some sort of legal guardianship for the child to make decisions on behalf of the child. And so that's why I'm throwing guardianship into this, because it's hard. It's one thing to get the divorce and get the child support handled. It's another to be able to make sure that this is a long-term care package that you put together. So when you get the divorce, what my client did not do in his divorce was provide for support after the child turned 18, even though they had language in there that said that the child in fact was disabled. So what happened there was, now we had to file a modification of the child support case to address child support after the age of 18, number one. And number two, we had to do a guardianship, which was going to be required anyway. But the child support aspect of things didn't have to happen. That could have been something that was addressed in the original divorce decree when they got divorced, even though both parties knew that that was what was happening, what was going on. The other reason that I recommend that is the court has authority and jurisdiction to continue the support after the age of 18, and that's covered under 154.306, which is that there are specific factors that are involved with how much that child support will be once the child turns 18 or is no longer a minor. And there's the difference there is in the normal child support case, you're only looking at the income of one spouse. And when the child turns 18, the family code now looks at multiple factors of what's to be considered for the amount of child support that's needed. Obviously, the whole basis for after 18 is what's called a needs-based, okay? And so you determine what is the needs of the child, what's the cost, what's the that this child needs, what's the medical cost that this child might need. Those kind of factors factor in. The income of both parents is considered versus just one. Then there's also a comparison of how much each parent contributes to the child. In other words, how long does each parent stay with the child? And in my case, the parents did like a week on, week off with the child to kind of share the duties with the child. The other thing about special needs children is that there needs to be structure for a child that has disabilities like this. And so, the regular standard possession order that we have may not be in the best interest of a special needs child. Many doctors will tell you that I've visited with that they highly recommend a specific week on, week off, or some sort of a transition where you minimize the numbers of times that the child gets swapped between parents. So, the date that I usually tell people is best to swap is usually a Sunday, for instance, because that's usually, the less traffic day, number one, for dropping off, and number two, there's not usually events on a Sunday evening or afternoon, and so that makes the drop-off and pickups a lot easier. And the last thing I'll mention about that, the Family Code also mentions under 154.309, what is that the code allows for possession and access in an order for a child that's an adult disabled child. The difference here, which is kind of unique, is that your adult disabled child has input into whether or not they'll make the visit. So that's the one aspect that's kind of different once a child turns 18 or is an adult disabled child. Family Code allows that the adult child now has input into that possession order, essentially. So let's talk about structuring the special needs trust. Number one, you're going to need to pick a benefit. The beneficiary obviously is going to be the child. And so what you're going to want is who's going to be the person, the trustee, who manages your trust. So if you're going to put it in a will or you're going to create it, you're going to want to put at least a primary person who's going to be the trustee of the special needs trust. Number two, you're going to probably want to pick an alternate, just in case that something ever happens to your primary, then at least you have a secondary person. Similarly, when you do a will, I always recommend you not just pick your spouse or a significant other. I always recommend that you always pick a secondary person to be your executor. That way, if the first person or you, the two of you, happen to be in a common disaster, at least you have somebody that's outside that window. So those are some factors to try to consider when you're designing your special needs trust. The reasons for a special needs trust obviously is to safeguard and provide financial support without jeopardizing government aid. And once you look into the special needs area, you're going to learn all kinds of government programs that are out there, and let's talk about those now. And the reason that that's important is this. If, in fact, you have child support being paid while a child is an adult disabled child, that may cut off their SSI or supplemental security income. That may also cut off their SSDI, which is their disability income. So for that reason, you do not want to have child support paid after the child turns 18. Until the child turns 18, obviously all of our orders say that the money's being paid to the custodial parent. Well, that's not going to the child, that's going to the parent. But after the child turns 18, then that income can be deemed to be income to the child and jeopardize government benefits. So the main reason the special needs trust came about and the ABLE accounts came about was to avoid harming these disabled children or them losing their benefits because child support or some sort of support was happening for the child. If you look up the Texas ABLE account, you'll see that the whole purpose of why they created that whole account was specifically to deal with that particular issue. In fact, they have other accounts that are available through that same institution, but we're not going to get to that today. The next thing is the SSI and Medicaid. If you've got a special needs child, more than likely they're going to be on SSI or SSDI. Normally that requirement means that you have had to go through some sort of a medical testing or medical documentation with the government to basically show that this child in fact has a medical disability or medical issues that require substantial care and supervision and not able to support themselves. Those are all the standards for why we would have a special needs case and why there would be this support being paid after the age of 18. Now, for the Medicaid side of things, you have to keep in mind that a lot of these cases, depending on the kinds of special needs issues, have a lot of medical related issues and a lot of medical related things. So you definitely don't want to lose Medicaid from a child situation because there can be significant cost involved with a special needs child. So those are reasons why creating the special needs trust and creating these ABLE accounts are very important. So what happens is basically anybody who's over the age of 18 can create a special needs trust. Obviously, I highly recommend you hire an attorney to create this so that it meets all the legal requirements and doesn't jeopardize your SSI or Medicaid benefits. If it's a testamentary one, which means that you would have put this in your will, then your executor of your estate would be the one hiring an attorney to put together the special needs trust. And here's how a trust works. Number one, if it's set up correctly, then what you're going to want to do is put any and all assets and or income streams into this trust. What that does is it shields it from the child, but it allows the person who's the trustee of this trust to pay any and all reasonable expenses of the child. And I mentioned earlier that those expenses are pretty broad, wide, and ranging, everything from their health to their quality of life. So, there's a whole wide litany under the IRS code that indicates that they're pretty open-minded about whatever those costs might be, and that would include medical, obviously, and that would include wheelchairs. That would include any kind of medical equipment. That would include any kind of housing or shelter that the individual may need. It also may include, transportation. In other words, if you had to pay for transportation for the person to go to and from rehabilitation or therapy or counseling, those kind of things, all of those things would be covered by the cost that you could use for the Special Needs Trust. The other reason that I like a Special Needs Trust is if we were to be involved in a guardianship with this case, and we were using that to be the sole tool for why you did things, then you would have to be accountable to the court for every dollar you spent to the guardianship, because on an annual basis, if you have a guardianship, you have to do annual accountings. And not only that, you have to do annual accountings on their health, wealth, and wear and other things like that. So for that reason, that's why I like the Special Needs Trust, so that you don't necessarily have to have a guardianship of the estate, because you've already taken care of that with this trust. That doesn't preclude that you wouldn't need the guardianship of the person, so that you'd be able to make medical decisions and other things for the child without people questioning your authority. So after the child turns 18, those are aspects that you have to throw into the mix that no longer are there orders out there that some places might honor. For instance, if my client had chosen to include child support for life, visitation for life, all of those things, there are still institutions and entities out there that say, well, you're still not, they may consider that not, you're not the legal guardian of this adult, so therefore you don't have jurisdiction. I mean, that would require you to do one of two things. One, go back to the court and get a court order that orders that this entity would have to do what you want them to do. Or two, you'd have to go create a guardianship so that this entity would cooperate with you. That entity sometimes might be the government. And so if that's the case, then you're probably going to end up having to do the guardianship. So in my case, we did both the guardianship and the child support case, but we made it simple with regard to the fact that the whole side of the guardianship case was that we were going to do the Special Needs Trust, and that would be and meet their requirements for the guardianship of the estate of the child, an adult now. Let's talk about some of the benefits out there. The first ones that I want to go through out there, and these are reasons why you don't want to lose these government benefits out there. There's a lot of them. The first one I'm going to cover is what we call outpatient services. Outpatient services go through the Texas Children's Health Plan, and that's known as Community First. That's the state/government entity that manages these particular plans. The first one is the Community First Choice Personal Attendant Services and Habilitation. And this program is considered consumer directed, which means that if you're the custodial parent or you are the guardian of the person of the adult special needs child, the state will basically pay you a certain number of hours for you to have health care for the child or habilitation services for the child. In my case, they approved 22 hours a week. So that gives the parent or custodial parent or the guardian at least a break during the week so that they can do things without, because sometimes you may not even be able to leave the child. So for that reason, the state's going to allow 22 hours a week for you to bring a specialized person in, or you can pick somebody who you trust to be able to do the health care for the child. And in my case, it was the older brother who's over 18 and had been living with the child. Basically the brother took care of him. And so what they do is they'll pay up to 22 hours a week for that health care. I don't know the exact dollar amounts that may be involved, but nonetheless, it's at least $14 an hour. It's a pretty good rate, or higher, that they'll pay for that, what they call consumer-directed services. And what that means is that you direct, and they're going to send you the money, and obviously, where are you going to put it? You're going to put it in the Special Needs Trust, right? And then with the Special Needs Trust, you're going to pay out those providers that come to your house and help you with the adult disabled child. The second program, that's also a state program, is called Respite Care, RESPITE care. And in my case, the government had approved 31 hours a week of respite care. And so that's also paid similarly. Where would you put the money? You'd put it in the Special Needs Trust and then administrate it out to the individuals who are assisting you. Now, the beauty of the Special Needs Trust, what I just told you, is you're not accountable to the court with regard to those funds, but you're accountable to yourself. And so that's the reason why I highly recommend you get the special needs trust and set it up this way versus going through just a pure guardianship of the estate type scenario. The next area is the ABLE account that we've already talked about, and I mentioned to you earlier that that's something similar to the special needs trust. It's just a different way of being able to handle it. The next area that we talk about is SSI or SSDI. Obviously, those are going to be, you have to meet the government requirements for them, and then, of course, they will then provide some sort of a financial assistance to you based on the fact that the child has met these specific requirements of the government. Lastly, we'll talk about, with regard to these benefit areas, is government benefits, and there's a bunches of them. And a lot of these depend on applying for them and then staying on waiting lists for a good period of time. At least that's my experience with my clients. The first one is called MDCP. That's the first one. The second one is CLASS, that's CLASS. The third one is HCS. I love it. Everything's an acronym. Then there's the HCBS. Then there's the Texas HML. And lastly, there's the STAR Plus. Bottom line is this. When you apply through Medicaid, these are all the different programs that you can apply for your child. The class, I'll give you a good example. The class in several of these programs are ones that will exist for you after the child's 25th or 26th birthday. So the respite care and the rehabilitation programs that we talked about earlier are usually programs that go till the child turns 25, and then you can apply for these other programs to supplement them after that age bracket, basically. So that's the reason I mention all of these, because what you'll want to do is, while you're on these first two programs, you could continue on those, but if the class program, for instance, just happens to be a higher class, right, of care, and then obviously it really depends on how much care and need and time a child may need of health care. It would allow you to get into the more I'll call beneficial programs, but the reason for them being more beneficial is that you're dealing with child care and or needs that are more higher needs than others. So that's why the government has you apply for all of them, and then you figure out which ones you actually get to do. So let's do a kind of a summary of what we're talking about today with regard to the special needs trust. Number one, you're going to have a beneficiary. Number two, you're safeguarding your child's government aid. Number three, you're protecting the SSI and the Medicaid and all these other benefits we talked about. We're talking about you setting this up either through your will or we're setting it up through a divorce. And then we describe that when the child turns 18, child support shall be paid to the special needs trust. The Texas Family Code, and even we used to work with the Attorney General's office. Even the Attorney General's office now acknowledges a state, because the state agency, that child support can be paid out to a special needs trust. Obviously, that's imperative if you're involved in the child support world and working with a child support case, that you ensure that your order specifically states that once the child turns 18, child support shall not be paid through shall be paid by the state disbursement unit to a special needs trust, or that the payments will be made directly to the special needs trust, one way or the other. The AG, or the Attorney General's office, doesn't necessarily like to be involved for life for a child, so I would tell you that your best bet on putting in an order is that once the child turns 18, that the Attorney General's office is no longer involved in the case. Then you will make direct payments to the special needs trust through a trustee that's listed in the divorce. That way, at least you've minimized continued contact with the Attorney General's office and the Child Support Division and all that, and you basically have made sure that you're still obligated, because if you don't pay after the child turns 18, you're still going to be under a court order. There still can be orders to enforce that after the child turns 18. So, review. A, you're doing this for the financial security of your child and keep government benefits. Number two, you're doing it for the flexibility and the control. You're not involved in the guardianship court to do these things. Number three, you preserve eligibility for the child and the government benefits. Number four, it's simple and understandable. The special needs trust is not complicated. It's straightforward. And lastly, and this is a bonus item, life insurance. People don't think about this, but if you have life insurance payable to your special needs child, you'll want to go back and change your policy or your beneficiaries on there to state that you want that to be paid to the special needs trust for your daughter or son. So those are some things that, in other words, all of this is designed basically to secure the future of your beneficiary, which is your son or daughter that has the special needs. And I'll open it up at this time for any questions. And you can use the chat feature to let me know if you have any questions. Well, seeing none, I'm going to go ahead and give you guys a little, I'll call them bonus tips. And what those will be basically is that you'll want to do your homework when it comes to what programs are out there for the government benefits, number one. Number two, a little more insight into those benefits is they only allow one parent to basically be the manager or person who can contact the government with regard to all those programs I mentioned. So under the respite program, under the attendant habilitation programs, only one representative can be that person. And so what you'll see is that, and what I did in our case, just to give you an example, is one of the parents is involved in those two particular programs, in managing those programs. The other parent, and they're co-parenting obviously, is involved in maintaining the other government benefits or making the application for those other benefits. So, and so what we did was we allowed the one parent to manage the funds, which would be the custodial parent, right, in most instances. In our case, we were able to also get what's called a co-guardianship. So we were able to get both parents to be guardians. And how we did that is we separated out the rights and duties of each of the parents. In other words, which parent is making which decisions, and you set it out. Ironically, the guardianship code and the family code are very similar with regard to rights and duties of parents and or guardians. So, yeah, that's not surprising, right? Because we're dealing with, individuals. So that should be the case. So just giving you a heads up that you can separate out those rights and duties just like you do in a divorce. You can do that in a guardianship case. And hopefully you've got my whim on the fact that if you're going to apply for guardianship of the person, not necessarily the estate. That's the whole purpose of why you did the special needs trust to begin with, and or that was the reason you may want to go create a ABLE account to set those particular things up. I will say that normally the ABLE accounts are accounts, most people are not real familiar with that. And I lean towards wanting to recommend people to go get the special needs trust. There's just not a lot of entities that are aware of an ABLE account or what it is. Whereas almost anybody knows what a special needs trust is, and you won't have trouble down the road when you're dealing with the funding and or things. But keep in mind that everything you have, including your life insurance, needs to go in benefits and or even your retirement accounts or things of that nature. Any account or bank account you have, you'll need to make sure that your beneficiary is not your disabled child. It would be the trust for the disabled child. So keep in mind that those are all legal advice I give all my clients with regard to these kinds of cases. And you want to do that on the front end, not the back end. So you don't want to wait till you get divorced to go do that stuff. You'll definitely want to make sure you have this planned out long before, because if something to happen to you even during the divorce, then obviously there may be repercussions, or you may lose some benefits for the child, which is not what you clearly intended to have happen. So hopefully this presentation gave you some really good insights into a special needs trust and the simplicity of it, really. And the fact that it really is a very, very valuable tool when it comes to being able to keep your government benefits and your government funding. Basically, as I told you, the two programs we talked about today, the respite and habilitation programs, are financial, basically funding for you to take care of your child. So those are critical. The other part is that you get to pick who takes care of your child. The government doesn't. So that's a huge benefit, even though they're giving you the funds to do it. So that is the value of that program. Also, you need to know on both of those programs, it's an annual requalification. Okay, so it's not like you get it once and you get it forever. So hope you enjoyed this presentation. Have a great day. And now hopefully you've learned all you can about a special needs trust. You guys take care. Have a good day.